Greetings everyone, I am Nurul Hafiza binti Ismail and today here I am. I will help you to have better understanding of tort law in subtopic negligence. First of all, what is tort law? A civil wrong that causes someone to suffer loss or harm and resulting in legal liability for the person who commits the wrong. In civil law, torts are ground for lawsuit to compensate a grieving party for any damages or injuries suffered. Basically, of the tort action lawsuit must be present of these three elements. Firstly, the tortfeasor or the defendant had duty to act or behave in a certain way. Second, plaintiff must prove the behavior committed by the tortfeasor did not conform to the duty owed to the plaintiff. Third, plaintiff suffered an injury or loss as a result. Next, we are going to talk about three types of tort, which is the negligence, nuisance, and the trespassing. However, let's talk more about negligence. So, what is negligence? Negligence means lack of proper care and attention, or in other words, it's careless behavior. Basically, negligence is a failure to take reasonable care to avoid causing injury or loss to another person. So, let me give you a simple example on how negligence can be. When you are playing your phone during driving and then accidentally cause an accident to the other road user, so here you will be sued as your unreasonable behavior for playing phone and accidentally cause harm to others. In winning the lawsuit against the defendants, it must be proven by these three elements, which is the first one is duty care, second one is breach of duty care, and the third one is remoteness of damage. Duty care. Duty care is an obligation imposed on all persons in society to exercise reasonable care in all their dealings. Basically, the defendant owes the plaintiff duty of care. If plaintiff cannot prove the defendant owes a legal duty, then there can be no breach of that duty and no recovery or even compensation in negligence claim. The existence of duty care depends on the type of laws where different legal tests apply to different laws. It is implied by parents to children, employers to employees, school to pupils, hotel to guests, common carriers to the passenger, or even the jailers to the prisoner. They all have the policy of duty of care in case the negligence happen and harm other people. To resolve duty care, Latkin has been enunciate neighbor principle that provide adequate basis in Donahue versus Stevenson in bracket 1932 AC 562 is the foresight of the reasonable man, where the rule that you are loved your neighbor becomes in law and must take reasonably foresee would be likely to injure your neighbor. It also stated the person who are so closely and directly affected by my act, and I ought reasonably to have them in contemplation as being affected when I am directing my mind to the acts or omissions which are called in question. Breach of duty care. In case Vaughan versus Menlove show the defendant owes duty care to claimant or the plaintiff, and if he acts below the reasonable standard, then breach will be committed and the defendant may be liable for the negligence. So how the breach of duty care will be determined? The court will examine whether in the given circumstances the defendant had taken such measure as a reasonable man test.
Reasonable man?
Reasonable man is an ordinary man that not have particular skill that possessed by the surgeon or lawyer, and so on, or unless the defendant is actually one. For example, a driver who speed through an unmarked intersection without stopping did not behave in a reasonably prudent manner. A reasonably prudent manner driver would have slowed and completely stopped in order to avoid possible accident can occur. However, court will determine the magnitude of risk can occur, the importance of the object attained, and the practicability of precautions as factor of breach of duty care. So let's go one by one. First thing first, the magnitude of risk, which the degree of care that made up of two elements which are likelihood that injury will be incurred and seriousness of the injury that is risk. Second, the importance of the object attained, where was it reasonably possible that you will be injured as a result of the other person's action. And lastly, the practicability of precautions. The risk must balance against the measure necessary to eliminate it, and the practical measure which defendant could take must be considered. What was up to standard yesterday may be not up to the standard today, as the standard keeps changing with the improvement and the modernization. Lastly, the remoteness of damage is the consequences of the wrongful act may be endless. No defendant can be made ad infinitum for all the consequences which follow his wrongful act. The defendant is only liable for consequences which are not too remote or proximate. That is it. We are done for negligence tort law. Therefore, before we end, let's start your brain with some quizzes. The first question is, what principle is involved in Donahue versus Stevenson in bracket 1932 AC 562? A. Neighbor principle. B. Accountability. And C. Principle of reputation and privacy. And the answer is A. Congrats if you done it right. If not, no worries, I got some more. The second question is, tort law apply when A. When involving reputation of someone or injury, and B. Robbery and drunk driver. And yes, well done. The answer is A. You strike again. Let's go to the last question. And the last one, what happened if the plaintiff or the claimant fail to prove evidence of negligence? A. The defendant can sue back. B. The plaintiff cannot ask for the compensation for any negligence claim. And yes, the answer is B. Good job for answering the question. And that's all for today. Thank you.